Mr. Bravenik, how much time are you all asking for voir dire?
For what? I'm sorry.
How much time are you all asking for voir dire?
Well, I think the state has an issue that they want to talk to you about. So I don't think they want to ask for any time for voir dire.
Oh, no, this is going.
Well, I think they've got a legitimate argument. And I hate to say that, but I think it's a fair argument.
Judge, and I guess we were going to have this hearing closer whenever we were about to go on this. So we subpoenaed 2 witnesses in this case yesterday. We have a jail call last night from the defendant telling these witnesses not to appear.
All right, that sounds like forfeiture by wrongdoing. So the confrontation clause doesn't apply. So what's the issue?
So that was just something that we were just going to file a motion, Judge. I just hadn't had the time to work on
okay.
Just because it was pretty short notice. And we had just uploaded the jail call just because it happened last night.
All
Well,
right.
I mean, this is new information to me, and this changes my.
What begins as a routine courtroom scheduling discussion takes a dramatic turn within moments. The atmosphere changes instantly when the prosecution reveals that the defendant allegedly made a jail phone call the previous night, instructing witnesses not to appear in court. The unexpected disclosure catches everyone off guard and immediately raises the stakes. The defense attorney is visibly surprised by the new information, explaining that the evidence changes the entire approach to the case and leaves the defense unprepared. Despite those concerns, the judge shows little willingness to delay the proceedings, emphasizing that the case has already been pending for a long time. With the courtroom under growing pressure, what started as a standard pretrial discussion quickly transforms into a tense legal confrontation. Every decision from that point forward is shaped by the alleged jail call, setting the stage for a heated battle over fairness, procedure, and the consequences of the defendant's own actions.
Last night, this wasn't a jail call that has been sitting around forever. If it's a jail call that was made last night, the state wouldn't know about it until they looked at it.
And I wouldn't know about it until this morning.
Yeah. So you all are on notice. He's alleged to have made a phone call. You have it. Have you turned it over to the defense?
My understanding is that our paralegal uploaded it in the case this morning.
Just have them give it to him now. Let him listen to it. Let his client listen to it. This case is going to trial. He's been in jail, and this is 5 settings, so it's going.
Judge, the only other thing, so we did get discovery. There was a co-defendant in this case. The discovery mainly pertains to the co-defendant. That's what I've been uploaded this morning as well, but we weren't going to use any of the co-defendant items.
This is going to trial today.
The courtroom atmosphere shifts into high gear as the judge makes it unmistakably clear that the trial will move forward without delay. While the defense insists that the newly discovered evidence requires additional time to review and could significantly impact their preparation, the court refuses to slow the proceedings. The judge stresses that the timing of the evidence is a direct result of the defendant's own alleged actions. If the jail call was made the previous night, the court reasons that neither the prosecution nor the judge could have known about it any sooner. From the judge's perspective, the case cannot be postponed because of circumstances the defendant may have created himself. As the exchange continues, the defense argues that their trial strategy has been disrupted and that moving forward raises serious due process concerns. Even so, the judge remains unwavering, signaling that the trial will proceed as scheduled. With every objection denied, the defense appears to lose its footing while the pressure inside the courtroom continues to build.
In due course of law. I have not had time to do that. It will adversely affect my client. I understand you have the absolute right as a trial judge to call my case. I cannot keep you from doing it. I don't prefer to do things twice. So that's why I'm raising the issue.
I understand what issue you're raising. This is going to trial. If he made a phone call allegedly,
I don't know.
Recently, well, we're going to find out. They're going to give you the phone call. He'll be able to listen to the phone call. But if he made a phone call last night and it's something new that they didn't know about beforehand and they're just getting it, it's gone. So
that's an interesting interpretation of law.
I know. I appreciate the interesting interpretation. But that's what happens when clients make phone calls from the jail and think that the phone calls are not recorded, when it clearly says when somebody's making a phone call, this phone call is being recorded. And then the person on the receiving end of the phone call.
I understand the argument. I'm simply telling you as a litigator that it changes the trial strategy. I believe it does affect his due process rights, and I will want to make that
Well,
Absolutely. As they put it, there is no other kind of clear but crystal on the record.
oh,
And then you may overrule that.
Yeah.
I may then cite the case law that tells you you're wrong. You may ignore that. And then
oh, let me just tell you what's going to end up happening. I'm not hearing any motions for continuance unless a motion for continuance is filed and filed properly. And number two,
Well, now, how would I do it in writing when I just found out about it? All right, so I will go back to the office and I will prepare that motion for continuance,
and then I will hear it. And if I'm telling.
At this point, the defense firmly pushes back, arguing that the late disclosure of evidence has created serious due process concerns. The attorney insists that the unexpected development has altered the entire trial strategy and that proceeding without adequate time to prepare would be fundamentally unfair to the defendant. The judge, however, remains unmoved. While acknowledging the defense's objections, the court makes it clear that the trial will not be delayed. Even the possibility of filing a motion for continuance does little to change the judge's position, as of the most intense moments of the hearing. The defense focuses on protecting the defendant's procedural rights, while the judge emphasizes keeping the case on schedule and holding the defendant accountable for the alleged circumstances. The result is a tense courtroom standoff that underscores the ongoing balance between legal protections and judicial discretion. Case has already been pending for an extended period. The exchange marks one.
Case that we already have on the docket. I don't know that my client needs to be up there, but we can.
Which case is this? Furlough?
That Eric Gonzalez Lopez, the one where Mr. Berrocal had been having visits with my
Yes.
client.
Judge, so defense came this morning. There was some indication in conversations with the detective looking into whatever's happening with that other guy. That there may have been video conferences with her client that, again, we had it pulled. We didn't think to pull them. Defense is asking if we can pull them. I know that's going to take a bit of time though.
Well, and just to let the court know, so one of my issues throughout this case, and I'm going to have to kind of tiptoe around a little bit, is that I've always felt that my communication with this young man, who is only just barely 18 years old, so, and all that entails, I think I've been very concerned once I found out about this gentleman having these visitations with my client and other people, that somehow had impacted my client and my client's family not to be able, for fear, confusion, influence of this other person, to not be able to have the types of conversations, honest conversations that we needed to have. I think that's impacted this young man's perception of his situation, of my role, of what's going on here. I'll remind the court, I know you already know, but he's not from this country. He comes from a system that's very different from ours. And so when I spoke with the detective who's investigating the case, who reached out to me, he did let me know that he believed that there were actually some video recordings of these visitations. And so I am keenly interested in seeing those, because I am desperate to have any kind of input or clue about why my communication with my own client has been so greatly impacted. And this is
The hearing takes a more emotional turn as the defense attorney shifts the focus away from legal procedure and toward the defendant himself. Describing him as a very young man who may have been influenced by someone outside the courtroom, the attorney argues that outside interference may have affected his understanding of the case. The mention of unusual jail visitations and possible video recordings introduces a new layer of uncertainty, raising questions about what may have occurred behind the scenes. As the attorney continues, the argument becomes increasingly personal and urgent. Concerns about fear, confusion, and possible manipulation replace the earlier debate over courtroom procedure. Rather than focusing solely on legal strategy, The defense emphasizes the importance of determining whether the defendant fully understood his situation and was able to make informed decisions throughout the case. The discussion shifts from technical legal issues to the human side of the proceedings. The defense urges the court to consider whether outside influences may have compromised the attorney-client relationship and affected the defendant's ability to trust his own counsel, adding an emotional dimension to an already tense courtroom battle.
But this case has been on the docket for an extremely long time. I understand the issues that you're facing, but bring him out, talk to him. And if it will help you all, I'll let him know, let his family know that that person is not an attorney. Hasn't been to, as far as I know, he hasn't been to anybody's law school in this country or anywhere else. And he's at I believe he's at the Bexar County Jail now.
That's correct. But would I be sorry?
Yes.
Would I?
Yeah, that was
Yes.
I'm afraid to even say anything. Would I be able to would the court entertain just a short continuance for me to review those?
They don't even know where the videos are or videos.
The detective certainly knows, and I have his name and his contact information and everything.
I mean, you can discuss with your client, but I don't see how these videos are impacting this case unless that person visited him and gave him some information that was Brady. And I don't think
there's no way for any of us to know unless we look at it, and I sure would hate to find that out after the fact.
Oh, if you all find it out after the fact, then that sounds like a new trial. But this case has been on the docket an extremely long time.
So you're denying my request to have access to those videos prior to the beginning of the trial?
I'm denying a request for what it sounds like people want to continue, and so I'm not continuing this case anymore.
Could I at least ask the state to see if they can provide those to me at any time?
Sure.
As soon as possible.
All right. Does anybody want to call the detective? I'm sure if they've investigated, he has the video.
Well, I was also going to call our investigator to see if there were any jail calls because it's
okay.
As the hearing reaches its final moments, the judge remains firm in the decision to move the case forward. Despite lingering questions about potential video evidence and the defense's request for additional time to review it, the court refuses to grant any further delay. The judge emphasizes that the case has already been pending for a significant amount of time and that the trial must proceed as scheduled. The defense continues to argue that the missing information could prove to be important, warning that if relevant evidence is discovered only after the trial, it could create serious legal issues and potentially lead to future challenges. Even with those concerns on the record, the judge stands by the decision, making it clear that the possibility of additional evidence is not enough to justify another continuance. The hearing concludes with several important questions still unanswered, leaving the outcome uncertain as the case moves into trial. Whether the disputed evidence will ultimately affect the proceedings remains to be seen, adding one final layer of suspense before the courtroom battle begins. Don't forget to like the video, subscribe to the channel, and turn on notifications so you don't miss future courtroom highlights. Thanks for watching, and we'll see you in the next one.